Well, here we are, our final part of what is intellectual property. This lecture is very interesting for the reason that everything that you have, your hair, your voice, your accent, if you're thinking of me, or your accent, your looks, your mannerism, the way you walk, everything, it's your property. And if somebody, and the question came up, you know, what about all this cosmetic surgery that we try to look like somebody else? Well, that's fine. However, if having the cosmetic surgery to look like somebody else, and then you want to use that look of somebody else to make money without the other person's consent, that's when you get into trouble. The whole point is it's unfair to make money on somebody else's property. And one of the problems we have today is what is property. And you see that pretty much, again, any information, anything that you have that has economic value and it's reasonably protected is copyrightable information or product or whatever you call it. So is the use of another person's name, likeness for the benefit of the user intellectual property? Invasion of privacy. This is the right under our Constitution. A person has a right to solitude and freedom from prying public eyes. Nobody should stare at you. This is why we have problem with cookies in the internet, because that could be stalking, where people are, some advertising company or whoever is following you on which site you click and which one you don't. And next thing you know, they send you advertisement about those sites that you went. That's stalking. That's following you, and that's really, and of course you have the argument that it's easier for me then to have all those sites ready so I don't have to waste hours looking for other sites. But anyhow, there is an invasion of privacy, so just keep that in mind. So tort law also safeguards these rights through the tort of invasion of privacy. And if you remember, tort is a personal injury between two people. This is civil action. It's nothing to do with criminal law. Again, what then do we have invasion of privacy versus intellectual property? In the following cases, we revisit the tort of invasion of privacy under misappropriation of a person's right to publicity, have been arguably stretched to cover intellectual property. This is very, very interesting because especially celebrity, and some of us wants to look like the celebrities, we want to wear their clothes, we want to wear, I mean, where is that fine line that it's my property and I don't want you to use it for something that I don't agree with it. And the biggest problem we have, and this is a statute again, celebrity cannot advertise a product on TV or on the radio and newspaper unless they use the product. Because we have a tendency to rely that if they use it and look how gorgeous they look, then I can use it the same thing. So that was the beginning of this thing of invasion of privacy versus intellectual property. For example, in a case involving a Ford Motor Company television commercial in which Betty Midler sound-alike sang a song that Midler had made famous, the court held that Ford, for their own profit in selling the product, did appropriate part of her identity. So here is Betty Midler. They picked somebody that sound like her because she did not want to advertise, or she didn't want to sing in that commercial. And she sang a song that Midler had made famous, and next thing you know, for Ford profit. And here is something, her voice alone was enough to make consumer think that she had been paid to endorse the Ford car. And this was used again then in 1992 when a less famous performer, Tom Waits, won against Frito-Lay advertising agency, which had a singer imitate Waits' gravelly voice and distinctive delivery in a jingle to sell tortilla chips. Very interesting, and he was not as famous as her. This was also a pure voice case since only the sound, not the song, was being copied. Yet Mr. Waits won $2.6 million, $2 million in punitive damages. This is the voice only. The other one was the voice and the song. Evasion of privacy again versus intellectual property. In a new textbook, you have the White versus Samsung and Doge Associate, 1992. The core rule, similarly in this case in your textbook, Vanna White, the hostess of the popular television game show Wheel of Fortune, against Samsung Electronics America, Inc. Without White permission, Samsung included in an advertisement for Samsung video cassette recorder a depiction of a robot dressed in a wig, gowns and jewelry posed in a setting that resembled the Wheel of Fortune set, in a stance for which White is famous. And the core rule in White favor, holding that the tort of appropriation does not require the use of a celebrity name or likeness, but only that the people might be misrepresented. The court stated that Samsung robot and left without a doubt as to the identity of the celebrity that the ad was meant to depict. So, here's something to discuss. Is there intellectual property at stake in this case? Do you see it as intangible property that they should be asked for their consent? And if they do consent, then can they receive some kind of percentage? How might copyright law apply to this case? This is the Vanna case. What interest must be balanced by a court to determine whether to let an advertiser create an ad that parodies a celebrity? Which side of the case is an ethical superior position? When you taking a stand between the two, then which one has more of an ethical superior position? And finally, please read Promoting Access to HIV/AIDS Pharmaceuticals by Mary Shug. Interesting article because it goes into the TRIP agreement and the purpose, and this is the international, the global economy that we have. And it was signed by representatives from over 100 nations in 1994. Not every nation is part of this agreement, only about a little bit over 100, so that's important too. It was one of several documents that were annexed to the agreement that created the World Trade Organization, or WTO, in 1995. The TRIPS agreement established for the first time standards. Here we go again. There's a standard for international protection of intellectual property rights. Just like we have standards for polluting the air, we have standards how to treat each other. You know, that when do you have a legal duty? Well, depends on, we learn if you have a special relationship, if there's a contractual. There's a standard. We have standards how to, and that standards is really ethical standard that reflects the prevailing culture that made this country what it is today. And that standard now is becoming law, whether it's under the Constitution or a statute. Usually it's a statute because it's for the good of society. So this is where, in this agreement, internationally now, we made a standard for intellectual property rights, including patent, trademarks, and copyrights for movies, computers, programs, books, and music. This is global. And it's very difficult because you have to get this 100 nations to agree. And we have a lot more than 100 nations, but that's what's so interesting. We have problem in our countries to have 50 states agree to make one law, uniform commercial code, for example, or a federal law. So can you see how difficult it must be for having over 100 nations to agree on certain terms and conditions of the agreement? While the TRIPS agreement requires members to protect copyrights, it makes no similar provision for requiring an international fair use exception. There is no fair use exception in the TRIPS agreement. Does this matter? Who would benefit for such a requirement to have a fair use exception? And who would be hurt by it, by not having it? Which seems most fair? Compulsory licensing, parallel importing, or generic manufacturing? And you see these three terms explained in the article because they're all part of the TRIPS agreement. Please post your view on the bulletin board. And again, which ethics has a stronger or more of a balanced weight when it comes to an international community or a virtual community or a global economy for the good of society at large, not just the United States, for the good of society at large. Thank you.